Imagine if the government said, we're going to limit some of your fundamental rights. If the most basic law of our country had an escape clause. Well, it exists. Welcome to Canada's Notwithstanding clause. The highest law of the land is the Constitution. The Charter of Rights and Freedoms makes up part of that document, and it guarantees some pretty big stuff. Freedom of expression, freedom of assembly, the right to vote, the presumption of innocence, and other things. Generally, a federal or provincial government can't pass a law that infringes on those rights. And if there's a dispute, the Supreme Court has the final say. Except if the government uses the Notwithstanding clause. Yes, there actually is a part of the Constitution that allows governments to disregard part of the Constitution. It's called Section 33. Now, it doesn't apply to the whole Charter. It can't be used to take your right to vote away, for instance. But it can be used to limit freedom of expression, religion, or assembly, and other broad sections of the Charter like life, liberty, and security of the person. The federal government has never used it, but the provinces have, with increasing frequency in recent years. So, why would Canada even have a clause like this? It was included in the Charter when it was created in 1982. The provinces worried that the Charter would hand the federal government too much power. They also didn't want judges to have the final say on all legislation. The Notwithstanding clause was added to the Charter to make sure that the provinces could enact laws without too much interference from Ottawa or the courts. The only limit to the Notwithstanding clause? If a government uses it, it expires after 5 years. But after that, governments do have the option to renew it. Like in 2019, when Quebec used it to forbid public servants from wearing religious symbols, and Quebec renewed it in 2024.